Okay, guys, this is probably the last chapter we're going to get to. So, a couple of vocabulary words before we start chapter 23, which is the right to a jury trial. There's prosecution and defense. Those are the two different teams of lawyers. The prosecution is the team that tries to prove somebody is guilty, and the defense is the team that tries to prove somebody innocent, tries to help them beat their charges. An expert is someone who knows a lot about something. Impartial means fair and free-minded. A verdict is the decision, usually guilty or innocent. And a juvenile is someone who's under 18 years old. So, let's imagine this situation. You've been arrested for robbery, and your trial is starting. You're sitting in a courtroom, you've got 12 jury members. They're all looking at you, and they are not happy to be there. They're missing work, they're not getting paid, and they feel like they're wasting their time. Nobody's smiling, and the prosecution is going to try to prove you're guilty. They have all their evidence laid out. They have scientists and people that are saying you are guilty for sure. Everybody is waiting for your team of lawyers, the defense, to present their case. You know that you are innocent, but you're still nervous. They have all this evidence they say proves you're guilty. Is it possible they could convince the jury you actually did it, even though you didn't? Sometimes that happens. So, how can you get a fair trial with all these odds stacked against you? In today's lesson, we're going to talk about what protections the Constitution gives you to try to ensure your trial is fair. So the Constitution has a couple different amendments that were set up to make sure you have a fair trial, the 5th, 6th, 8th, and 14th. What those things do is they protect you from spending needless time in jail. So what that means is they have to give you a fair bail. If you're accused of a crime, they have to set the bail at a fair level so you can be out of jail while awaiting the trial. Now, there's certain circumstances where you don't get a bail if you're accused of a terrible crime or they have lots of evidence against you. Trials cannot be held in secret. They must be public. You have the right to your own lawyer, and both the defense and prosecution must follow the same rules. And if you think your trial was unfair, you have the right to appeal. So when people are sent to jail, you lose lots of your rights. The Constitution changes a little bit when you're in jail. Sometimes people are accused of crimes they did not commit. That does happen. There's entire podcasts and radio shows and YouTube channels set up showing people who were accused and convicted of crimes they didn't actually do. In the United States, people are supposed to be innocent until proven guilty. So what that means is unless they can prove you committed the crime, you are supposed to go free. Having a jury look at the case and the evidence is one way we try to help ensure that justice is carried out and that innocent people are not convicted. In a trial, the prosecution tries to prove that somebody is guilty, and the defense tries to prove they are innocent. When they wrote the Constitution, they knew that a public trial was the best way to make sure the truth got put out there. Because if you have a trial in public, it's a lot harder for shady stuff and some shenanigans to go on behind the scenes. If everything's out in the public, they can't really break the rules. So there's a couple things that are set up to make sure you have a fair trial. The defense is entitled to know the charges you're accused of. So you can't be arrested and sent to jail and never told what you did wrong. They have to tell you what crime you committed, and they have to tell you what evidence they have against you. So what that means is at the trial, they can't keep secret evidence. If they're going to show some fingerprints or some surveillance video they say is you, they have to give that to your team of lawyers so you can look at it and examine it and try to disprove it. Both teams have to follow the same law, and the jury is supposed to be impartial. And what that means is they are supposed to come into this case with an open mind and look at it not thinking you're guilty or innocent, and just listen to the facts. The 5th, 6th, 8th, and 14th Amendments are all set up to lay the groundwork for fair trials. So before a trial, a jury is guaranteed by the 6th and 14th Amendments for any crime where you're looking at a jail sentence. You don't get a jury for a parking ticket or for a speeding ticket or for probably even for shoplifting, a candy bar. Juries are set up for things where you are facing potential jail time. The trial must be speedy and public. So the Sixth Amendment gives you the right to a speedy trial. So why would you want your trial to happen quickly? Let's pretend that you got accused of a terrible crime, kidnapping children, and you get arrested, put in jail, and they set your bail high. And they set your trial for 3 months down the road. So for the next 3 months, you're sitting in jail, and everyone there thinks you kidnapped children. It's going to be rough. If you ask for a speedy trial, they can speed up the trial date, and they usually have to have it within 30 days. Some states it's 60, but that all depends. All parts of the trial must be open to the public to guarantee that the trial is fair. In some cases, there's exceptions to it. The judge can order a private trial, and usually that is in cases that involve minors. So think back to that documentary we watched a little while ago about Larry and Brandon in California. There was no video from inside the trial. All we saw were those drawings. And that's because they weren't allowed to have people in there watching the trial because it was involving children and minors. The accused has the right to a lawyer for all the important parts of the case. They have the right to appear to defend themselves and answer questions on the stand. And opposite of that, they also have the right to remain silent, protected by the Fifth Amendment. In the previous chapter, we talked about how if you don't have a lawyer, they have to provide you one. They have to give you one so you can adequately defend yourself. The prosecution and the defense both have to follow the same rules. There's certain rules for a courtroom about when people are allowed to talk, what kind of evidence is allowed to be presented, what kind of questions are allowed to be asked. The prosecution has to tell your team what evidence they have against you and what witnesses they're going to call. The reason why they have to do that is so you have time to dispute those facts and fight the charges. If they could just come in with all this secret evidence that you never saw, it would be really hard for you to say that's not you on the surveillance video or that's not your footprints or fingerprints. Your lawyers need time to look at that evidence and cross-examine it. In some cases, a defendant may want to have a trial moved to another county. So think back to that documentary we watched. Brandon's lawyers wanted the trial moved to the next county over. The reason why they did that is they said that it was all over the news and everybody was already saying Brandon was guilty. They didn't think he could get a fair trial. Well, in that case, the judge looked at it and the judge decided not to move the trial. But there's been cases where trials have been moved to the next county over to try to find a jury that wouldn't be influenced by the media and the newspapers and things like that. It may be impossible to get a fair trial if everyone on the jury thinks you're guilty before it even starts. And that has happened sometimes. You see somebody on the news being taken out of their house in handcuffs and being walked to the car. That persuades people. That changes people's mind, even if the person is innocent. During the trial, any kind of trial where you're facing serious charges, you are guaranteed a jury. 12 people are on a jury, and they're usually chosen from the area where you live or where the crime was committed. And for a verdict, for a decision to be made, all 12 members must agree. So 12 out of 12. If not, they could have a mistrial where they do the whole trial over again. You have the right to an impartial jury. And what happens when people get called for jury duty? They're picking 12, but they might start off with 100 possible people. And then your lawyer is going to ask those jury members questions. And the other lawyer is going to ask those jury member questions. And they end up crossing off people until they get it whittled down to 12 people on the main jury. People who are charged with a crime have the right to know all the evidence and all the charges against them. It is illegal to charge somebody with a crime and not tell them what you're charging them with, and to not tell them what evidence you have, and to not allow them to go to the trial and defend themselves. Defendants can call witnesses to prove they're innocent. Sometimes witnesses might not want to come to court, and they can be subpoenaed, which is a requirement to come in and testify. The accused has the right to remain silent, like we just talked about. The Fifth Amendment guarantees you that right. And what that does is it allows you to not talk, at your trial. You don't have to take the stand. You don't have to speak. It doesn't allow you to just not answer questions. Like if you take the stand and start answering questions, you have to continue answering. But the Fifth Amendment allows you to refuse to take the stand and not answer any questions. After the trial, the Eighth Amendment protects you from unfair sentences. And what that means is if the jury decides you're guilty and the judge is going to give you a sentence, the sentence has to fit the crime. So they can't give you a major sentence for a minor crime, and they can't give you a minor sentence for some major crime. If you are found guilty, you have the right to appeal, which remember is when you ask a court to take a second look at your case. And usually they will provide a lawyer for your first appeal. And in an appeal, they're not deciding if you're guilty or innocent. They're just trying to decide if your decision or your court case was fair. Okay, so I'm going to tell you guys a story about a court case where things really didn't go right and this guy did not get a fair trial. So juveniles are treated somewhat differently than children when it comes to court. Usually they're tried in juvenile court, but that's not always been the case. In May of 1964, or one day in June of 1964, a woman named Marjorie Galt comes home and she finds out her son Gerald, 15 years old, was not at home. She finds out he got arrested and taken to juvenile hall because him and his friend were making obscene prank phone calls. So they were prank phone calling people, and he got arrested for it. Police came, handcuffed him, took him to jail. When she went to juvenile hall, she found out that he was on trial the next day. So she doesn't have time to get a lawyer. She doesn't have time to fight the charges. He's going to trial tomorrow. At the hearing, Miss Galt and Gerald came without a lawyer. The trial was not public. There was no recording made. No one took notes. And it was unclear whether Gerald confessed to making the phone calls or not. His mom said the neighbor has to come in. She has to come in and tell her side of the story. And the judge said, nah, she can stay home. And that's not how it works normally. If you're going to accuse somebody of a crime, you have to be willing to go to court and testify. Gerald had been in trouble twice before. One time he got accused of stealing a baseball glove. And then another time, his friend got picked up with a stolen wallet on him. So Gerald's not really a bad kid. He's got two minor things, and one of them wasn't even really him. So the judge listens to Gerald's case, and they decide to put him in the State Industrial School, which is basically a juvenile detention school where he cannot leave, and he will be there until he is 21. So he is getting 6 years in juvenile detention for making prank phone calls. Gerald's parents appealed the case. They said this is not fair. They took it to a lower court and then eventually to the Arizona Supreme Court. They said they had no time to prepare. They didn't have time or a chance to even question the woman who was accusing them. And no one told Gerald of his Miranda rights. They didn't tell him he could remain silent. They got him just answering questions. He was a young, scared, nervous kid. Both of the appeals courts turned down the case. They said, nope, the decision is upheld. He's still guilty. The court said a juvenile hearing is not the same as a trial, and they had to follow juvenile laws. They said that juveniles are not guaranteed the same rights as of adults. So Gerald's parents appealed the case to the United States Supreme Court, the highest court in the country. During the hearing, the Supreme Court justices asked why Gerald's sentence was so harsh. 5 or 6 years for making prank phone calls. And the lawyers said, well, he's not really going to jail. He's just going to school. And the judge said, can he leave? And the lawyer said, no, he's got to stay there. So the judge said, since he can't leave, it's no different than jail. In the end, the Supreme Court sides with Gerald and his family, and the decision is overturned. They also decided that if a juvenile is being charged with a crime where they're facing similar punishment to an adult, they have to get the same kind of representation and rights in court. Okay, guys, so I need you to go into Google Classroom, open up chapter 23, and knock out the worksheet.